Judge Sonia Sotomayor tries to silence John Kennedy, but John's reply shocks the courtroom. The Supreme Court chamber was a monument to justice, its marble columns rising like ancient pillars, its high ceilings adorned with intricate friezes that seemed to whisper of centuries of legal tradition. On this morning, however, the air was thick with an electric anticipation, as if the very walls sensed that something extraordinary was about to unfold. Spectators streamed into the gallery, their footsteps soft against the plush carpet, their hushed voices carrying a mix of excitement and reverence. Many had arrived before sunrise, enduring long lines to secure a seat for a session that promised to be historic. The case before the court, Henderson versus Texas, was no routine matter. It was a high-stakes showdown over voting rights and congressional redistricting with the power to reshape the democratic voice of millions. At the heart of this drama stood Senator John Kennedy of Louisiana, a Republican known for his folksy wit and sharp intellect who had been granted the rare and controversial of presenting oral arguments before the nation's highest court. His presence was a lightning rod sparking debate among legal scholars and court watchers who saw it as either a bold step toward bridging the gap between Congress and the judiciary or a dangerous breach of the court sanctity. The gallery was a tapestry of faces, legal scholars clutching note-tips, veteran reporters poised with pens, and a small group of Kennedy's con students from Louisiana, their eyes wide with pride and nerve. These ordinary citizens had traveled to Washington to see their senator speak for them, and in a place few ever entered. The chamber's grandeur, its polished mahogany bench, its soaring architecture only heightened the sense that history was in the making. Behind the bench, the 9 justices took their seats, their black robes a stark contrast to the gleaming marble surroundings. Among them, Justice Sonia Sotomayor sat with an air of quiet intensity, her dark eyes scanning the room with a blend of curiosity and weariness. Renowned for her incisive questioning and unwavering commitment to fairness, Sotomayor was a towering figure on the court, her journey from humble beginnings to the federal bench, a testament to her brilliance and resolve. Today, however, her posture hinted at unease, a subtle tightening of her jaw, a faint tap of her fingers against the bench that those who knew her recognized as a sign of skepticism. Whispers had circulated that Sotomayor, a fierce guardian of the court's traditions, was uneasy about Kennedy's. To her, the Supreme Court was a sacred space for legal rigor, where constitutional questions were debated with precision and precedent, not a platform for political figures to grandstand. The decision to allow Kennedy to argue alongside Department of Justice lawyers had ignited fierce debate long before the session began. Some saw it as a necessary evolution, a recognition that elected officials could bring a unique perspective to issues that directly affected their constituents. Others viewed it as a risky precedent, fearing it could blur the lines between the judiciary and the political branches, undermining the court's independence. The case itself, Henderson versus Texas, was a tinderbox. At issue was whether states could redraw congressional district lines in ways that critics argued diluted the voting power of minority communities. A ruling in favor of Texas could give states sweeping authority to reshape electoral maps, potentially altering the balance of power in Congress for generations. For Sotomayor, whose judicial career was defined by her defense of equal protection and voting rights, the case was deeply personal. For Kennedy, it was Son's opportunity to advocate for a balanced approach to federalism, one that respected state autonomy while ensuring fair representation. The stakes were monumental, and that chamber hummed with the knowledge that the outcome could redefine the contours of American democracy. As Chief Justice John Roberts called the session to order, the room fell into a reverent silence, the weight of the moment settling over the chamber like a heavy curtain. Kennedy stood at the podium, his navy suit crisp, his demeanor calm but purposeful, his voice laced with the distinctive Louisiana drawl that had made him a standout in the Senate. Carried a quiet authority. Your hunters, he began, his tone steady. I stand before you today, not just as a senator, but as a voice for the people of Louisiana, who know firsthand how thorough governing our elections shaped their lives. He paused, letting his words resonate, his eyes sweeping the bench. Justice Clarence Thomas, typically reserved, leaned forward slightly, a rare sign of interest. Justice Samuel Alito's pen paused mid-note, his expression one of cautious attention. Justice Amy Coney Barrett, usually buried in her meticulous notes, looked up, her curiosity evident, but it was Sotomayor's reaction that drew the most scrutiny. Her fingers tapped once sharply against the bench, a gesture that court regulars knew signaled disagreement. Kennedy pressed on, undeterred, blending legal analysis with the lived experiences of his constituents in Louisiana. He said, I've met folks in places like Lafayette and Monroe, people who've seen their communities fractured by district lines drawn to favor one group over another. These aren't just maps. They're barriers to the promise of equal representation. His argument was anchored in precedent-setting cases like Baker, Vicar, and Shaw versus Reno, but it was his emphasis on the human impact of redistricting that set him apart. The gallery leaned in, captivated by his ability to make the complexities of constitutional law feel immediate and vital. The tension in the room was palpable, a coiled spring ready to snap. Justices Neil Gorsuch and Brett Kavanaugh launched early questions, probing Kennedy's legal reasoning. Gorsuch, a staunch defender of state authority, asked whether Kennedy's argument implied that states should have no flexibility in managing their elections. Kennedy responded with a folksy analogy. It's like a farmer dividing his land. You can draw the lines however you like, but you can't cut the field. So the crops can't grow. The gallery murmured in appreciation, and Gorsuch offered a faint nod. Kavanaugh direct challenged whether Kennedy's approach ignored precedents, like Shelby County v. Holder, that granted states leeway in electoral matters. Kennedy held his ground, citing Thornburg v. Jingles and explaining how gerrymandered districts in Louisiana had systematically disadvantaged minority voters. His command of the law surprised even his skeptics who had expected more political charm than legal substance. The gallery, a mix of supporters and critics, began to see Kennedy as a formidable advocate, bridging the courtroom and the communities he represented. But it was Sotomayor who would spark the moment that defined the session. As Kennedy launched into another example, a story of a New Orleans community whose voting power had been diluted by a redrawn district map, her patience wore thin. Senator Kennedy, she interrupted, her voice slicing through the chamber like a blade. This court is not a forum for storytelling. We are here to interpret the Constitution, not to hear anecdotes about your constituents. The room fell silent, the weight of her words hanging heavy. The court stenographer paused, her fingers hovering over her machine. Sotomayor continued, her tone firm and authoritative. Your role here is to present legal arguments grounded in precedent and constitutional principles. Personal stories have no place in these proceedings. The rebuke was a thunderclap, a rare public reprimand from a justice known for her commitment to fairness. Reporters scribbled furiously, sensing a headline in the making. Kennedy stood at the podium, his face unreadable for a brief moment. Asked gallery held its breath. Had Sotomayor just silenced a United Statesinator in the most public of forums? The silence stretched, taut, and electricous, every eye fixed on Kennedy. Then, to the astonishment of all, a slow, confident smile spread across his face. Not a smile of defeat, but one thought suggested he had been waiting for this moment. Justice Sotomayor, he began, his voice calm, but resonant with the greatest respect for this court and your distinguished service. I must respectfully disagree. The gallery gasped, a ripple of shock coursing through the room. Had a senator, a Supreme Court justice, she was wrong. The stage was set for a confrontation that would reverberate far beyond the marble chamber. The Supreme Court chamber, already charged with the electorate aftermath of Senator John Kennedy's bold retort to Justice Sonia Sotomayor, seemed to hold its breath as Louisiana senator stood at the podium, his eyes steady and his voice unwavering. The marble columns loomed excellent witnesses to a confrontation that had just escalated from a procedural rebuke to a profound challenge of judicial philosophy. Kennedy's assertion that the lived experiences of American citizens were not just relevant, but essential to constitutional interpretation, had landed like a thunderbolt, and the gallery, packed with legal scholars, reporters, and curious onlookers, buzzed with a mix of awe and Sotomayor, her face, a mask of controlled intensity, leaned forward slightly, her dark eyes locked on Kennedy, as if measuring the weight of his words. The other justices, too, were visibly engaged. Justice Clarence Thomas, typically stoic, kept his gaze affixed on the senator, while Justice Samuel Alito's pen hovered motionless over his notepad. Even Chief Justice John Roberts, known for his iron grip on courtroom decorum, seemed momentarily at a loss, his usual instinct to steer proceedings back to order overridden by the sheer gravity of the moment. Kennedy, undeterred by the palpable tension, pressed forward, his Louisiana drawl carrying a blend of folksy charm and razor-sharp precision. Your Honors, he said, his voice steady but infused with a quiet passion. The Constitution is on a dusty textbook sitting on a shelf. It's a living promise to the people of this country, and when we talk about voting rights, we're talking about the heart of that promise. He paused, letting his words sink in his eyes, sweeping the bench. In Louisiana, I've seen communities torn apart by district lines, drawn to dilute their voice. I've heard from farmers in St. Landry Parish, who feel their vote doesn't count, from teachers in Baton Rouge, who see their neighbor hubs carved up to favor one party over another. These aren't just stories, Your Honor, they're evidence of what happens when the law forgets the people it's meant to serve. The gallery stirred, a low murmur rippling through the crowd, quickly hushed by the bailiff's stern glance. Kennedy's words were striking Gackard, not just with the spectators but with some of the justices. Justice Amy Coney Barrett, her notes momentarily forgotten, tilted her head, her expression one of genuine curiosity. Justice Brett Kavanaugh, however, leaned forward, his brow furrowed. Senator Kennedy, he interjected, his tone measured but probing. Are you suggesting that this court should prioritize these anecdotes over established precedent? The Voting Rights Act, in cases like Shelby County v. Holder? set clear boundaries for federal oversight of state elections. How do you reconcile your approach with those limits? The question was a classic Kavanaugh have a move grounded in precedent, designed to force the speaker to navigate a narrow legal tightrope. Kennedy didn't flinch. Justice Kavanaugh, he replied, a hint of a smile playing at the corners of his mouth. I'm not asking this court to ignore precedent. I'm asking you to apply it in a way that honors the reality on the ground. Shelby County struck down parts of the Voting Rights Act, but it didn't erase the Equal Protection Clause. When district lines are drawn to weaken the votes of certain communities, that's not just a policy choice. It's a constitutional violation. He cited Thornburg versus Jingles, a landmark voting rights case with the ease of a seasoned litigator, explaining how its criteria for detecting vote dilution applied directly to the Texas case. The gallery murmured again, impressed by Kennedy's command of the law. Even Kavanaugh nodded slightly, acknowledging the senator's deep response, but it was Sotomayor who remained the focal point of the room. Her earlier rebuke had set the stage for this clash, and her silence, since Kennedy's retort, was deafening. Now, as Kennedy continued to weave real-world examples into his argument, she could no longer hold back. Senator Kennedy, she said, her voice cutting through the chamber with the precision of a scalpel. You speak of Thessa communities and their struggles, and I don't question their importance. But this court's role is to interpret the law, not to act as a legislature responding to constituent concerns. Are you suggesting that we should bend constitutional principles to accommodate popular sentiment? The question was loaded, designed to box Kennedy into a corner, either admit to advocating for mob rule or retreat from his emphasis on real-world impact. The gallery held its breath, and even the other justices seemed to lean in, sensing a pivotal moment. Kennedy, however, was ready. He stepped closer to the podium, his posture relaxed, but his eyes burning with conviction. Justice Sotomayor, he said, his voice calm, but resonant. I am not suggesting this court bend anything. I'm saying that constitutional principles exist to protect people, not to exist in a vacuum. When the court decided Brown versus Board, it wasn't just applying the Equal Protection Clause, it was recognizing the harm done to children, like Linda Brown, segregated by law. When it decided Gideon, Verda, Wainwright, it wasn't just citing the Sixth Amendment. It was giving a voice to people like Clarence Gideon who couldn't afford a lawyer. Those cases weren't about abstract theory. They were about real people, real harm, and real justice. The chamber was so quiet you could hear theft and rustle of papers on the bench. Sotomayor's expression remained unreadable, but her grip on her pentaton a subtle sign of the impact Kennedy's words were having. He preceded, his voice growing stronger. In Louisiana, I represent over 4 million people. They sent me here to make sure their voices are heard, even in a chamber. When we talk about voting rights, we're not just debating legal technicalities, we're deciding whether those people get a fair shot at democracy. If this court rules that states can redraw districts to silence certain voices, that's not just a legal decision, it's a decision that tells millions of Americans their votes don't matter as much as someone else's. The gallery erupted in a low hum of reaction, quickly stifled, but the energy in the room was undeniable. Kennedy had turned Sotomayor's challenge into an opportunity, reframing debate as a question of the court's fundamental purpose. Justice Neil Gorsuch, known for his textualist approach, interjected with a question about federalism, asking whether Kennedy's argument encroached on states' rights to manage their elections. Kennedy responded with a metaphor comparing states to chefs in a kitchen. They can cook the meal however they like, but they can't leave half the table starving. The analogy drew a chuckle from the gallery and even a faint smile from Gorsuch, a rare moment of levity in the tense proceedings. But Kennedy's focus remained on Sotomayor, who was now leaning back in her chair, her eyes studying him with an intent made the room feel smaller. Justice Sotomayor, Kennedy continued, addressing her directly. You've written powerfully about the importance of fairness in the law, about making sure the Constitution protects everyone, not just those with power or privilege. I'm asking this court to do exactly that, to look at the people behind the precedents, the communities whose futures hang on your decision. If we ignore their reality, we're not interpreting the Constitution, we're rewriting it to exclude them. The words hung in the air, a directional edge to Sotomayor's judicial legacy. The gallery was riveted, and reporters were typing furiously, knowing they were capturing a moment that would dominate legal discourse for years. Sotomayor's face remained impassive, but her eyes betrayed a flicker of something surprise perhaps, or the dawning recognition that Kennedy's argument was not just rhetorical flourish, but a substantive critique of the court's approach. Justice Elena Kagan, typically quick to engage, jumped in with a question about the practical implications of Kennedy's argument, asking how the court could balance real-world impact with the need for clear legal standards. Kennedy responded with a detailed analysis of Shaw, Reno, explaining how the court had already set precedents for addressing racial gerrymandering without overstepping judicial bounds. His ability to pivot between legal rigor and human stakes was earning him respect, even from those who disagreed with his politics. As Kennedy's time neared its end, he delivered a final plea, his voice steady but infused with urgency. Your Honors, the people of Louisiana, and millions like them, across this country, aren't asking for special treatment. They're asking for the promise of the Constitution. A government of the people, by the people, for the people. If this court rules in a way that silences their voices, it's not just a loss for them. It's a loss for the democracy. This court is sworn to protect. The chamber fell silent, the weight of his words settling over the room like a heavy fog. Sotomayor, still silent, leaned back, her expression a mix of contemplation and resolve. The other justices exchanged glances, sensing that something fundamental had shifted. Kennedy had not just defended his right to speak, but had challenged the court to reconsider its role in a democracy. As he stepped back from the podium, the gallery buzzed with subdued excitement, and reporters were already crafting headlines. Sotomayor's next move would determine whether this clash would escalate further or pave the way for a deep one that could reshape how the Supreme Court and the people it serves understood each other. The Supreme Court chamber, still reeling from Senator John Kennedy's audacious challenge to Justice Sonia Sotomayor, seemed to pulse with a new kind of energy, a mix of tension and curiosity that crackled like static in the air. The marble columns, usually stoic and indifferent, felt almost alive, as if bearing witness to a moment that would be etched into the annals of judicial history. Kennedy stood at the podium, his navy suit slightly rumpled from the intensity of his delivery, but his posture remained resolute, his eye scanning the bench with the calm assurance of a man who knew he had struck a nerve. The gallery, a sea of legal scholars, reporters, and a handful of Louisiana constituents who had Medethy pilgrimage to Washington, sat riveted, their whispers hushed, but anticipation palpable. The clash over Henderson v. Texas, a case that could redefine voting rights and congressional redistricting, had transcended the usual boundaries of oral arguments, becoming a battleground for competing visions of the Supreme Court's role in American democracy. Justice Sotomayor, her earlier rebuke of Kennedy's storytelling, now a distant Tocho, sat with a posture that betrayed a subtle shift. Her stern demeanor softened, her eyes narrowed, not in disapproval, but in contemplation. The other justices, too, were visibly drawn into the unfolding drama. Justice Clarence Thomas, typically silent, kept this gaze fixed on Kennedy, a rare sign of engagement. Justice Samuel Alito, his pen still a dull, leaned slightly forward, while Justice Amy Coney Barrett's notes lay untouched, her attention wholly on the senator. Chief Justice John Roberts, ever the guardian of courtroom order, seemed to hesitate, as if reluctant to interrupt a moment that felt both fragile and momentous. Kennedy, sensing shift in the room, seized the opportunity to deepen his argument. Your Honors, he began his Louisiana draw, carrying a warmth that contrasted with Chambers' austere grandeur. This case isn't just about lines on a map, it's about the people who live within those lines. People who go to work, raise families, and cast ballots, hoping their voices will matter. He paused, letting his words settle, then gestured the gallery, where a small group of his constituents sat, their faces a mix of pride and nervous anticipation. I brought with me today folks from Shreveport and New Orleans. People who've seen their neighborhood split apart by redistricting plans that don't make sense unless you're trying to quiet certain voices. They're not here to tell stories for sympathy. They're hairbokas, their votes are the currency of our democracy, and right now that currency's being devalued. The gallery stirred, a soft ripple of agreement passing through the crowd, quickly silenced by the bailiff's sharp glance. Kennedy's words were hitting home, not just with the spectators, but with the justices who were beginning to grapple with the human stakes he was laying bare. Justice Elena Kagan, known for her incisive questions and knack for cutting through legal jargon, leaned forward, her expression one of genuine interest. Senator Kennedy, she said, her tone measured but curious. You've made a compelling case about the impact of redistricting on your constituents. Butho, do we translate that into a legal standard? The court needs clear principles to guide lower courts, not just compelling narratives. How would you propose we draw that line? It was a fair question, one that tested Kennedy's ability to bridge the gap between the real-world consequences, he emphasized, and the court's need for judicial clarity. Kennedy nodded, acknowledging the challenge, and responded with a clarity that surprised even his skeptics. Justice Kagan, I'd point you to Thornburg versus Jingles, where this court laid out a framework for evaluating vote dilution. That framework isn't just a legal checklist. It's a tool to ensure that minority voters, like those in my state, aren't systematically sidelined. What I'm asking is that you apply that framework with an eye to the reality it's meant to address. When districts are drawn to fracture communities, you don't just violate precedent, you violate the promise of equal protection. His response was met with a nod from Kagan, a sign that he had met her challenge head-on. But it was Sotomayor who remained the focal point of the room. Her earlier rebuke had sparked this confrontation, and her silence, since Kennedy's bold retort, had left everyone wondering how she would respond. Now, as Kennedy continued to weave the experiences of Louisiana voters into his argument, she leaned forward, her voice softer than before, but no less commanding. "Senator Kennedy," she said, her tone carrying a note of genuine curiosity rather than confrontation. "You've spoken eloquently about the people affected by this case. I don't dispute their importance, but this court's role is to interpret the Constitution, not to act as a forum for public sentiment. How do you propose we balance the need for legal rigor with the real-world impacts you describe?" It was a pivotal moment, a question that invited Kennedy to refine his argument rather than defend it. A sign that Sotomayor was engaging with this perspective rather than dismissing it outright. The gallery leaned in, sensing that the dynamic between the senator and the justice was shifting. Kennedy seized the opening, his voice steady but infused with conviction. "Justice Sotomayor, I'd argue that legal rigor and real-world impact aren't at odds, they're two sides of the same coin. The Constitution wasn't written for lawyers alone, it was written for the people. When we talk about equal protection, we're talking about a principle that only means something if it protects real people from real harm." In Reynolds v. Sims, this court said that fair representation is the foundation of democracy. If we ignore the voices of voters in Louisiana or Texas or anywhere else, we're not just misreading the law, we're undermining that foundation. He paused, his eyes locking with Sotomayor's. "I'm not asking this court to abandon precedent. I'm asking you to apply it in a way that keeps faith with the people it's meant to serve. That's not sentiment, it's justice." The chamber was silent, the weight of his words settling over the room like a heavy fog. Sotomayor's expression softened her eyes, betraying a flicker of respect, though her posture remained composed. The other justices to were visibly engaged. Justice Neil Gorsuch, typically skeptical of expansivatal roles, nodded slightly while Justice Brett Kavanaugh scribbled unnote, his brow furrowed in thought. Kennedy pressed his advantage, drawing onus specific example to drive his point home. In Louisiana, he said there's a community in Lake Charles where redistricting split a historically black neighborhood right down the middle. Families who voted together for generations now find their votes diluted across two districts, neither of which gives them a real voice. That's not an abstract legal problem. That's a constitutional injury. The Equal Protection Clause exists to prevent exactly that kind of harm. His voice rose slightly, carrying the passion of someone who had seen the impact firsthand. When this court decided Baker Vitt's car, it didn't just set a legal standard, it gave people like those in Lake Charles a chance to fight for their rights. I'm asking you to honor that legacy, not just for my state, but for every community that's been carved up in their vote. The gallery was spellbound, and even the court stenographer, usually focused on her machine, glanced up, caught in the moment's intensity. Sotomayor, her earlier sternness, now tempered by curiosity, leaned forward again. "Senator Kennedy," she said, her voice measured but warm. "You've given us a vivid picture of the stakes in this case. But let me ask you this. If we accept your argument, how do we avoid turning every constitutional question into a referendum on individual experiences? Where do we draw the line?" It was a softer challenge than her initial rebuke, an invitation to dialogue rather than a dismissal. Kennedy smiled faintly, recognizing the shift in her tone. "Justice Sotomayor," he replied, "I'd say the line is drawn where the Constitution draws it at fairness. The court's job isn't to near individual experiences, but to use them to test whether the law is doing what it's supposed to do. In Chavarino, you said racial gerrymandering violates the Constitution because it treats people as groups, not individuals. I'm asking you to look at individuals in those groups, the voters whose lives are shaped by this court's decisions. That's not a referendum, it's a responsibility." The response was a masterstroke, turning Sotomayor's own precedent against her while reinforcing his career argument. The chamber erupted in a low hum of reaction, quickly stifled, but its energy was undeniable. Sotomayor sat back, her expression a mix of contemplation and acknowledgement. For the first time, she nodded slightly, a gesture that sent ripples through the gallery. Reporters typed furiously, knowing they were witnessing a rare moment of Supreme Court justice, known for her fierce defense of judicial protocol, appearing to reconsider her stance in real time. Justice Kagan, sensing the moment's significance, jumped in with a follow-up question about the practicalities of implementing Kennedy's proposed standard. But it was clear that the senator's exchange with Sotomayor had stolen the spotlight. Kennedy concluded his argument with a final plea, his voice steady but urgent. "Your Honors, the people of Louisiana and millions across this country are watching. They're not asking for favors, they're asking for the Constitution to mean what it says. If this court rules in a way that lets states silence certain voters, you're not just interpreting the law, are redeciding who gets to shape our democracy. I trust you'll choose fairness over technicality." As he stepped back from the podium, the chamber buzzed with subdued excitement, and Sotomayor's eyes lingered on him, a silent acknowledgement that something profound had just occurred. The Supreme Court chamber, still vibrating with the intensity of Senator John Kennedy's historic exchange with Justice Sonia Sotomayor, seemed to exhale as the session drew to a close. The marble columns, which had stood witness to countless legal battles, now framed a moment that felt like a turning point, not just for the case of Henderson versus Texas, but for how the nation's highest court was perceived by the people it served. Kennedy, his Navy suit, slightly creased from the fervor of his arguments, stepped back from the podium, his face a mix of quiet resolve and understated triumph. The gallery packed with legal scholars, reporters, and a small contingent of Louisiana constituents buzzed with a subdued energy, their whispers barely contained as they processed the unprecedented clash they had just witnessed. The air was thick with the weight of what had transpired. A sitting senator had challenged a Supreme Court justice not with political bluster, but with a blend of legal precision and a passionate plea for the court to remain connected to the lives of ordinary Americans. Justice Sotomayor, her earlier sternness now replaced by a thoughtful demeanor, sat back in her chair, her dark eyes studying Kennedy with a mix of respect and contemplation. The other justices, Clarence Thomas, Samuel Alito, Amy Coney Barrett, and Elena Kagan, exchanged glances, their expressions revealing a shared recognition that something profound had unfolded. Chief Justice John Roberts, typically quick to restore order, allowed the moment to linger, as if acknowledging that the exchange had shifted the very atmosphere of the court. As Roberts gabbled the session, TOA closed. The usual orderly exit from the chamber gave way to a controlled chaos. Reporters rushed to file their stories, their fingers flying over laptops and phones, crafting headlines that would soon dominate news cycles. Senator Kennedy takes on Sotomayor in historic Supreme Court showdown. Legal scholars huddled in small groups, their voice low but animated, dissecting the implications of Kennedy's argument that the court's legitimacy rested on its connection to the people. The Louisiana constituents in the gallery, ordinaries who had traveled to see their senators speak for them, stood with a quiet pride, their presence a reminder of the human stakes at the heart of the case. Within minutes, the exchange was trending online with #KenNYV. Sotomayor becoming a viral hashtag. The Supreme Court's YouTube channel, typically a niche corner of the internet, saw its viewership spike as clips of the confrontation racked up millions of views in hours. Comments flooded in from viewers who had never watched a court proceeding before, many praising Kennedy's ability to make the law feel accessible, others debating whether his challenge had crossed a line into disrespect. Progressive commentators hailed Sotomayor's eventual openness as a sign of judicial humility, while others thought Kennedy's approach risked politicizing the court's sacred space. The ripple effects of the exchange were immediate and fair-yakking. Legal Twitter, a hotbed of scholarly debate, exploded with analysis. A prominent constitutional law professor tweeted, "In 30 years of watching the Supreme Court, I've never seen a moment like this." Kennedy didn't just argue a case, he challenged the court to rethink its role in our democracy. A conservative commentator offered measured praise. Agree or disagree with Kennedy? You can't deny his advocacy was masterful. He made the Constitution feel alive. Law schools across the country began incorporating the exchange into their curricula, with professors using it to spark discussions about the balance between judicial independence and public accountability. The National Bar Association issued a statement commending both Kennedy and Stewart for demonstrating that respectful dissent could elevate constitutional discourse. Even the Supreme Court itself, typically insulated from public reaction, took notice. In the weeks that followed, that court announced plans to enhance the accessibility of its oral arguments, including improved live streaming and simplified summaries of key cases. A move many attributed to the public resonance of Kennedy's plea for a court connected to the people. Off the bench, Sotomayor's demeanor in subsequent arguments hinted at a subtle shift. Observers noted that she asked more questions about the real-world impacts of cases, her tone less confrontation and more inquisitive. At a judicial conference, shortly after the session, she offered rare public comments on the exchange, speaking with a candor that surprised attendees. "I was reminded recently," she said, "that our role as justices is not to stand apart from the American people, but to serve them. That service requires not just legal expertise, but a willingness to listen to perspectives that challenge our own." Her words, though not a direct apology, signaled a remarkable openness from a justice known for her fierce convictions. Meanwhile, Kennedy's profile soared. His office was inundated with thousands of emails from across the country, teachers using the video in civics classes, young lawyers inspired to take on public interest cases, and ordinary citizens who felt for the first time that someone had spoken for them in the marble halls of the Supreme Court. Speaking requests poured in from law schools, civic organizations, and even international legal forums, all eager to hear from the senator who had turned a routine oral argument into a national conversation. The most unexpected outcome, however, was the professional relationship that developed between Kennedy and Sotomayor weeks after the session. The two met privately at a legal conference. engaging in an hour-long conversation that, according to a source close to the event, was marked by mutual respect. Sotomayor reportedly told Kennedy, "You pushed me to think harder about what justice means. That's what public servants owe each other." The exchange, though private, underscored the potential for constructive dialogue even in the face of sharp disagreement. Legal historians began to place the moment alongside other watershed Supreme Court events like Flood Marshall's arguments in Brown v. Board or Ruth Bader Ginsburg's advocacy in United States v. Virginia. A leading scholar wrote in a prominent legal article, Kennedy's challenge to Sotomayor wasn't a rejection of judicial authority, it was a defense of constitutional democracy, reminding the court that its power comes from the consent of the governed. The broader impact of the confrontation was a renewed national conversation about the Supreme Court's role. Law schools reported a surge in applications with Mooney students, citing Kennedy's performance as inspiration for pursuing careers in public service. Civic organizations launched initiatives to educate the public about the court's work, using the exchange as a case study in how elected officials and the judiciary can engage constructively. Kennedy himself used his platform to advocate for greater civic education, urging Americans to understand the Constitution not as an abstract document, but as a living framework for their rights. "The law isn't just for lawyers," he said in a televised interview. "It's for every American who believes their voice matters." His words resonated with a public increasingly wary for transparency and accountability from their institutions. The lesson: the confrontation between Kennedy and Sotomayor offers a powerful lesson in the value of respectful but fearless dialogue in a democracy. It demonstrates that challenging established norms when done with reason and respect can strengthen institutions rather than weaken them. Kennedy's insistence on bringing the voices of ordinary citizens into the courtroom did not undermine the court's authority. It reminded the justices that their rulings shape real lives. Sotomayor's willingness to listen and reflect showed that even the most powerful figures can grow through open engagement. Together, they modeled a form of democratic discourse that is both rigorous and inclusive, proving that disagreement can be a catalyst for progress rather than division for students, citizens, and public servants alike. The lesson is clear. Democracy thrives when we speak truth to power, listen to opposing views, and work together to ensure that the law serves the people it governs. This exchange, born in the heat of a courtroom clash, serves as a reminder that the Constitution is not a relic, but a promise, one that requires active participation to fulfill. As the echoes of that day in the Supreme Court chamber faded, the impact continued to reverberate. The confrontation had not only reshaped the discourse around Henderson vs. text, but had sparked a broader reflection on how the judiciary and elected officials can work together to uphold the principles of fairness and representation. That was a moment that reminded everyone inside the courtroom and beyond that democracy is not a spectator sport. It demands engagement, courage, and a commitment to listening even when the conversation is uncomfortable. What do you think? Did Kennedy's challenge strike the right balance, or did it risk crossing a line? The debate continues, and it's one we all have a stake.